Going back to order. I need a gavel. We are going to get started with the first of our three special panels dedicated to discussing the rule of law in challenging times. As you heard from our last panel, we don't live in ordinary times, and we thought this shouldn't be an ordinary program. And so there are three afternoon panels, view from the bench, view from the bar, view from the newsroom, about threats to the rule of law. And to get us started in the discussion, no one better than Richard Griffiths. My official introduction does not say this, but my unofficial introduction is that Richard Griffiths is a national treasure. For those of you who have been coming to this event before, you've enjoyed Richard's wit as he serves as a moderator and presenter, and I'm sure he won't disappoint again today. Richard worked for CNN for 25 years until his retirement in 2017.
Fact check, 26 years.
More
gray hair.
He was named editorial director in 2004, is that right?
1997.
Ah, well, this is your official bio off of the Judiciary website.
We'll talk to Charles Davis later.
I'm not going to read any more years. For some years previously, Richard was a producer with CBS News and had an exceptional career that included Peabody Awards, Emmy Awards, a Headliner Award, the National IRE Investigative Reporting Medal. He has served as an industry fellow with the James M. Cox Institute at the University of Georgia, as a board member for the nonprofit Trusting News, and he is the longtime face and voice of the Georgia First Amendment Foundation, where I am pleased to serve as a colleague on their board of directors. So take it away, Richard.
Thank you, everybody. Terrific group of people here to talk about rule of law. I'm going to go in alphabetical order, which was skipping around a little bit. Justice Blackwell, will you raise your hand for just a moment? He served more than 8 years as a justice of the Supreme Court of Georgia, served nearly 2 years as a judge of the Court of Appeals of Georgia. He is now senior counsel at Alston and Byrd in Atlanta. He graduated from the University of Georgia School of Law, clerked for the Honorable Judge Edmondson at the U.S. Court of Appeals for the 11th Circuit. Justice Michael Boggs, at the end, served as nearly every level of the state's judiciary. He began as a Superior Court judge in the Waycross Judicial Circuit. He was later appointed to the Georgia Court of Appeals by Governor Nathan Deal, who appointed him also to the Supreme Court of Georgia. And as Chief Justice, Justice Boggs created committees to address AI and the courts, legal regulatory reform, and judicial security. Earlier in his career, and I think this is really helpful for us today in discussion of rule of law, he also served in the Georgia House of Representatives. He got his BA from Georgia Southern, his JD from Mercer University School of Law, and is now a partner with Hunter McLean. Judge William S. Duffey, billed to his friends, was a United States District Judge who served in the Northern District of Georgia in Atlanta. He retired in 2018, and before assuming the bench in 2004, Judge Duffey served as a U.S. Attorney in the Northern District. And before his confirmation as U.S. Attorney, Judge Duffey was a partner of King & Spalding in Atlanta, and I believe you were also a JAG officer in the military. From 1994 through 1995, he served as Deputy Independent Counsel in the Whitewater investigation, leading the investigation in Arkansas. From June 2022 to September 23, Judge Duffey served as chair of the State Election Board in Georgia, which explains his gray hair. After his retirement from judicial service, Judge Duffey developed an active mediation, arbitration, and litigation consulting practice. He is now a candidate for a master's degree in theological studies, expecting to graduate later this year. And born in Macon, Judge Beverly Martin is a fourth-generation Macon lawyer, UGA graduate. She was a judge on the U.S. Court of Appeals for the 11th Circuit from 2010 to 2021, and prior to joining the Court of Appeals, Judge Martin sat for nearly a decade as a U.S. District Judge in the Northern District of Georgia. From 21 to 24, Judge Martin was the Executive Director of the Center on Civil Justice at NYU Law School. And before you were a judge, you were a federal prosecutor also, including as the U.S. Attorney for the Middle District of Georgia. And Beverly now volunteers at a Los Angeles-based post-prison re-entry program where she helps former inmates with legal matters. My plan is to ask questions for about 30 to 40 minutes, then open the floor for questions. I'm going to start with Justice Boggs. There are a lot of non-lawyers here, so let's start by defining some terms. What's the law?
I'm going to start with an easy one, it looks like. So when we think about the law in the context of the rule of law, it's obviously the body of law that judges and courts are bound constitutionally and by oath to interpret. And that includes regulatory matters, it includes decisional law, it includes text, and it includes constitutional law as well. So short answer, you asked me to keep it short.
Perfect. What's the rule of law, Judge Martin?
Well, I think same thing Justice Boggs says. I mean, it means a lot of things.
Come in close.
All right. The rule of law is the network of rules that allow us to live together in harmony. That's the way I think about it. I mean, I never thought of government as, the place, that imposes the morals of one set of people on other people that don't share them. So I think it's just a way for us to come together and be able to have roads and
Is it also that no person or institution is above the law?
well, I hope so.
Right? So the law applies equally to everyone. Judge Duffey, how does the rule of law play out in your courtroom?
Well,
Come
first,
in close to the mic.
There's also law in the Old Testament, which was given to Moses and came down on the tablets, so I wanted to make sure we didn't miss that.
Speak close to the mic.
The rule of law, I think, is a well-established, and rule of law, I think, needs to be defined according to what it is within our democratic republic. There are three, and this is for the people that are not lawyers, and I want lawyers to also think about it this way. There are three branches of government, you know that. Those three branches are established in the Constitution. It's the legislative branch, the executive branch, and the judicial branch. The Federalist Papers decide and describe those branches and Alexander Hamilton described the judiciary as it is designed to be the intermediate body between the people and their legislature, to ensure that the people's representatives acted only within the authority given to Congress under the Constitution. So the courts are supposed to protect the public from the actions and the authorities given to the other branches of government, which would include the executive branch.
So the president can't take your property or liberty without a judge giving an okay?
Well, that would be what we would tell somebody in the 5th grade, but it's more complicated than that, because if you look at this tripartite government and where they are situated with each other, the judiciary is on the outside of the other two branches of government. And that means that before the judiciary can decide what the rule of law, it has to be the rule of law as it exists in a particular controversy presented to it through the judicial system. And one of the things, and I told this to Richard when he asked me to do this, is that if you read the public commentary about various things that are ongoing in the country today, everybody thinks and uses the term rule of law in an entirely different way. Rule of law for us is the construct of the Constitution which places all of us, whether you're in state government or federal government, at that place where they are the adjudicator to protect the public against the actions of the executive branch and the legislative branch. And that is done only by presenting to them a controversy to be decided. And so the rule of law is what the court decides with respect to that controversy.
Justice Blackwell, what happens if people no longer trust in the rule of law as Judge Duffey has just laid it out?
Well, I don't remember which of the authors in the Federalist Papers, but certainly the Federalist Papers talk about the judicial branch as being the branch that does not possess the power of the sword like the executive branch does. It does not possess the power of the purse like the legislative branch does. And it depends almost entirely on the confidence of the public for its power and its ability to fulfill its role within this tripartite system that Judge Duffey talked about. And so if the public comes to lack confidence in the judicial system, comes to lack confidence in the very idea, the fundamental notion of the rule of law, then that's a real problem. The judicial branch effectively cannot function in that environment.
So how do judges protect the rule of law on a daily basis? What's the best way of doing that, Justice Blackwell?
Judges protect the rule of law first and foremost by following the law that pertains to the issues that come before them, and that also gives them their judicial powers, but also limits their judicial powers. And so I have always said in speaking to judges and speaking to lawyers that the judicial branch is a co-equal branch of our government. It has a very important role to play, but it is a limited role. And we always have to remember it is limited to, as Judge Duffey said, deciding particular controversies that come before the courts. And so one of the areas in which I think courts can protect the rule of law is by faithfully observing the limits of their own power, the limits of their own jurisdiction, and being very assiduous about that so as not to open themselves up to at least legitimate criticisms that they are exceeding their powers and that the judicial branch is blowing past the rule of law.
Justice Boggs, the latest data, and here I'm putting up some data from the state of the state courts polling from 2025. Conference of Chief Justices shows trust in the federal courts at 52%, down 5% from the year before. Trust in the U.S. Supreme Court at 51%, down 3 points from 2024. Trust in state courts largely unchanged at 62%, but when asked to rate state courts on how they are doing at their job, 50% of respondents said not well or not well at all. That's the worst review since the Conference of Chief Justices started surveying. These are pretty frightening numbers. What's driving these markers of distrust, do you think?
You know, I think the answer requires a lot of answers, quite frankly. I mean, ultimately, this NCSC, National Center for State Courts poll reflects, I think, public sentiment about their trust and confidence in courts. Obviously, I'm glad to see that public trust and confidence in state courts is relatively high and certainly higher than the other branches of government. But ultimately, I think what it is a reflection of is that the majority of citizens in the United States have no interaction whatsoever with the judicial system. None. And some that do are at such a lower level where in Georgia, for example, some of the interaction is with non-lawyer judges. We still have a lot of non-lawyer judges in Georgia. Many of them do a great job. But I think trying to discern anything from public sentiment writ large around from 300 million Americans about their public trust and confidence, I think it is a reflection of public sentiment as they gain, not from their experiences with the court system, but from what they read about the court system. And I'm not sure that that's a valid way for the public to get information about the validity of their court systems upon which we all so desperately rely on. I mean, ultimately, it's clear to me that when citizens lack public trust and confidence in the institution designed to protect their liberties, and they delegitimize the outcome of opinions, that has an inherent risk of jeopardizing the entire foundational structure of the rule of law and the whole role of the judicial system in protecting those sacred rights. So I'm always disappointed when I see that public trust and confidence is lower. I think there are many ways we can increase public trust and confidence in our state courts, and fortunately in Georgia, we have a lot of judges that are doing a lot of good work that I think helps build public trust and confidence for citizens that may never interact with the court, but they understand that the courts have a role constitutionally and otherwise beyond just deciding cases, live controversies, as Judge Duffey says. They also have a role in the administration of the courts.
Well, but Georgia is one of the most open states in the court system. There are cameras allowed in the Georgia courts. Audio, the Supreme Court has audio and video here. What other things could happen to rebuild trust in the courts? Do you have specific ideas?
Sure. I mean, I think when the public sees judges engaged in efforts to improve access to justice, we have 8 counties in Georgia with no lawyers, legal deserts in Georgia. Hard to imagine someone who is in their most dire straits situation in a custody battle, in a divorce battle, trying to probate their parents' estate, and don't have access to a lawyer. So I think efforts to try to remediate legal deserts, try to improve access to justice, are one ways that judges are engaged in the administration of justice that will help build public confidence. But so too are other efforts like our accountability court systems we have in Georgia. Mental health courts, drug courts, accountability courts, veterans treatment court programs. Those are the types of programs that I think the public sees judges engaged in as an effort to do something beyond just deciding live controversies, but rather improve the lives of people who intersect with the judicial system. And I think those are just 2 examples of many, trying to combat the effects of AI and generative artificial intelligence on the courts. And most of what judges do is retrospective, Richard. We decide live controversies. But when judges...
You're stealing my question order. Oh, I'm sorry. Yeah. Keep going, though. Keep going.
Well, when we decide these things retrospectively, we're trying to resolve a problem that has come to us after years of litigation, whether in the trial or appellate courts. But when judges engage in things prospectively to try to improve courts, I think these numbers reflect public sentiment about what people think about their judges and their judicial system writ large.
Bill Duffey, you were waving your hand wildly, trying to get my attention back then.
It wasn't wildly.
I'm a journalist. I get to exaggerate a little bit.
Well, a little bit. That's an interesting comment, because if you look at what the public sentiment is to the judicial system, the one place where I think that we need to tease out Justice Boggs is this, that you say what people read, or people don't read about the judicial system. People see what they believe the judicial system should do based upon televised, either on the internet or on, I guess there are no news programs anymore on TV. It's all of this flood of information that comes in the form of visual depictions that cause the people to say there's something wrong with my system. There's something wrong with law enforcement, there's something wrong with the judicial system, there's something wrong with the general system of democracy in the United States. And it's not working because of look at what I'm seeing. Now, I think the press has a lot of responsibility for what people see. And my example is this, that when I presided over the 2 terrorism cases that we had in the Northern District, we had a hard time making enough room, had an overflow room for people to watch the proceedings, but we set aside a separate place for journalists, which was a mistake on my part. I mean, I was trying to accommodate their access to the proceeding. But the most disruptive part of the audience during the course of a trial were the journalists walking in and out as they got what they needed in order for whatever the noon broadcast was, or the evening broadcast, or the late night broadcast. And I would talk, and then they said, well, why can't will you let us bring in our electronic devices so that we can make notes and then can send out what we're reporting. And I said, well, I would do that if I thought that you would stay, but you won't. I said, you cannot evaluate the testimony of a witness in the context of some, if it's an hour bit of direct examination and another hour and a half of cross, you cannot evaluate that witness's testimony by watching 15 minutes of the direct examination. And so even with cameras in the courtroom, people are not watching the entire proceeding. They're basically watching to get an idea of what the atmosphere is like, but they're relying upon some tidbit of the proceeding or the testimony that is extracted by journalists that shows up on the news.
Justice Boggs,
Yeah, my only follow-up would be probably more blunt, but I'll share it. And that is that I think much of public sentiment about public trust and confidence as reflected in that survey is born out of a misunderstanding of the role of judges and courts. I think much of it is outcome determinative, not analytical, and whether or not the court applied the law as written and reflective of the separation of powers and the obligations judges have to do that. And so to me, a lot of it is they don't like the outcome, and that's fair. And even criticism about the analytical framework of applying the law faithfully, as judges are required to do, pursuant to their oath, to the facts of the case. People can disagree on that too, but I think some of this is just we've gotten far afield from what the actual role of a judge is.
Justice Blackwell.
Yeah, so I think that's exactly right. Judge Duffey talked about a journalist trying to evaluate somebody's testimony based on seeing 15 minutes of it, or even a viewer who can watch live proceedings trying to evaluate it from 15 minutes. I think most of the public gets their news about the judiciary in a 30-second blurb or a tweet or whatever we call posts on X these days. I think that's how most people get their news about the judicial system, and I think Justice Boggs is right that it's often focused on the outcome, and they don't really know how to evaluate it. They don't know that they should be evaluating it in a different way, not simply based on outcomes. And I think that's largely a failure of the civics education that we give citizens in this country.
So is there anything that the courts can do to combat the real world that you're living in?
I think courts can, I think judges and lawyers certainly have a role to play in trying to educate our fellow citizens. But I think we need to, and I think maybe judges and lawyers should push for a restoration of a better system of civics education in our high schools.
Judge Martin, have you ever heard a case that went against the government or an administration? If so, who ultimately enforced that decision? Who enforces the decisions of the courts?
Well, that question has gotten a lot more interesting since I left the court, right? I mean, I remember a time when somebody was knocking on my door in the trial court needing a temporary restraining order because immigration officials were taking somebody to the plane to send them to Hungary when they had the legal right to be here. And I got on the phone with the immigration officer that was escorting this gentleman, and I said, don't put him on the plane. And he wasn't happy about it, but he did it. So I don't, I didn't worry about enforcement as much at that time. I think we've got some problems around that.
So talk a little bit more about what you're seeing today versus what you saw then.
Well, I mean, I don't know all the facts around these cases, but we definitely have judges in specifically the Washington, D.C. area that are saying they're ordering, don't put this person on the plane and the person's gone from the country. But I think that's something we need to reckon with as a society. I have an idea about something we could do to make the justice system more respected. So this takes me back to when I was in law school, and 1 in 5 of the law students in my class was a woman, so thank you for the stroll down memory lane. Anyway, Judges need to explain their opinions. I mean, I don't know if any of you have read this book called The Shadow Docket, written by a very wonderful law professor named Steve Laddick. If you just issue do this or don't do that, and people don't know why, or they don't know how you arrived at the opinion, then you're opening yourself up to criticism, and I say deservedly so. But if you explain why you're doing it, and the public is privy to the debate that led to the result that they've been asked to follow, that's a good thing.
Justice Blackwell, don't the courts have a constitutional balance of power role? How can they do that if they have no army, no police force? What happens if the executive removes that enforcement mechanism?
So if the courts find themselves in a situation where the executive simply will not enforce their decrees, I think there's actually little the court can do directly to have the decrees enforced. I mean, they do depend on the assistance of the executive branch in enforcing their decrees. That's why I talked about earlier, they depend on public confidence. They ultimately depend, I think, on political pressure being brought to bear by the public on the other branches of government to conform their conduct, particularly the executive branches, to the decisions of the court. And if the public is no longer willing to accept the decisions of the courts as the last word on these matters, I think we find ourselves in a very, very bad place.
Can I add something to that?
Yeah.
And that's been going on for a long time. I mean, and
Speak into the mic so they can hear you.
What Justice Blackwell just said, that's been going on for a long time. That there's this lack of public trust in the authority of the court. When I first went on the bench, it always amazed me that I could write an order, and at the end of the order require somebody either to pay an amount of money or to engage in some sort of conduct that they didn't want to engage in. And we didn't need it to be enforced. They said, that's an order from a federal district court. We had our say. We understand the reasoning behind it. And we are going to abide by it, or if we don't like it, we'll appeal it. And everybody understood that it probably took them 2 years to get to me. Probably took 2 years then to get an opinion from me. It took another year to have it decided by the Court of Appeals. And the chances of it going to the Supreme Court were not very high. But they respected the process. I think what we see from time to time in the culture is there's a period of time, there are moments when there is something that happens that erodes almost completely the public trust in the judicial law enforcement system. And you get a public that doesn't believe in the system any longer, and they decide to engage in anarchical conduct to show their objection to the way that things have happened. And that's why in my own life I said, I lived through the LA riots. I lived through the Washington, D.C. riots. In fact, it was in high school in Washington, D.C. when those were going on. When I was in undergraduate school, when there was objections to the Vietnam War, they bombed one of the laboratories of my school, and they bombed the ROTC building because they felt as if something was happening within the country. We've seen what happened at Harvard and in Columbia when they objected to what was going on within the culture. And if you go up the road to Chickamauga, you'll find that 33,000 men died in that battle because they disagreed with what the government's position was on slavery. And we saw a president in his first inaugural address say that he thought a unified and strong federal government was more important than the issue of slavery. And then 4 years later, he said, we've been in this terrible battle. People don't like it. We're ripping ourselves apart as a country. So they changed that political policy And ultimately, that has died down significantly. We're at least killing 33,000 people in single events. Now, what do we do about that? All of the things that the courts are doing to try to build public confidence is amazingly effective. I used to bring in at least once a year, sometimes more than that, because it was hard to get schools to do this, to come in just so I would have them sit and stand in the courtroom and I'd say, let me talk about the organization of the courtroom. Let me tell you how justice works. The lawyers are here. They're separated from the jury. The jury is separated from the judge. The witness is next to me because they see me as the protector of it. And the people that get to watch have to be behind that rail. I said, so let's talk about all those functions. And actually, the kids love that. Nobody has ever explained that to them. And the press doesn't explain it to them. Can I tell you why people have a misunderstanding? This is from July 14th, 2026, New York Times. A report on the challenge to the California voter-approved redistricting of the state for the purpose, everybody was clear about this, for the purpose of the election of Democrats to the House of Representatives, something that the state of Texas has just done. And we know the result of that was that that redistricting was approved and found to be constitutional. Then there is this. This used to not appear when I issued an opinion. Appears all the time now, except I'm not issuing opinions other than this one. This is what a journalist decided the public needed to know. 2 judges on this 3-judge panel in Los Angeles sided with Governor Newsom and fellow Democrats in Congress who argued that the maps were drawn partly to give their party an advantage in reaction to a similar gerrymandering by Texas Republicans. The ruling shot down arguments by the California Republican Party and the Trump administration that the maps amounted to a racial gerrymandering that focused on favoring Latinos over other groups of voters. Now, you can listen to that and you can decide whether or not that's been politicized, but you can't disagree that this is politicizing this opinion. District Court Judge Josephine Staten, an appointee of President Barack Obama, and District Judge Wiley Sue, an appointee of President Joseph R. Biden Jr., sided with California in the case. Judge Kenneth L. Lee of the Ninth Circuit Court of Appeals, an appointee of President Trump, dissented. You know, there's not a single discussion of the opinion and how they reached the conclusion that they reached, other than that summary, which I think was politicized. That's what the public gets. And the press, I think, is complicit in saying we look at everything that the judiciary is doing as a political outcome. And we do that because we politically appoint federal judges anymore, depending upon who's in power. And we fight about all of that. And does the public not trust the system? They don't. And I wonder whether or not they have a reason not to, because of the information that is fed to them.
Well, it's also, though, isn't it true, Judge Martin, that we've also had a political machine that's taken advantage of building distrust in the courts right now, in that Pam Bondi said back in June, President Trump's executive authority has been undermined since the first hours of his presidency by an endless barrage of injunctions designed to halt his agenda. This pattern of judicial overreach undermines the democratic process and cannot be allowed to stand. And today, with the ruling against President Trump by the Supreme Court, even while we've been meeting here on tariffs, President Trump called the Supreme Court justices a disgrace and announced new tariffs. Doesn't the White House have a point that aren't courts getting in the way of what President Trump was elected to do?
Well, I think their job is to get in the way of whatever president is doing something that they think violates the law. So, you know, I think, you know, I grew up in Macon, Georgia, where, you know, the ruling came from Judge Boodle to integrate the University of Georgia. And there's, oh, this is my brother calling me, so sorry. So.
Do you want me to get it for you?
No. So, you know, he was criticized and he was called out, and there were crosses burned in Macon with him as an LGBT. So this has been going on, but it's so universal now. And I'm kind of with Rodney King now. Why can't we just get along and love each other? I mean, that's the only way that we're going to get out of this, is to understand that we need to agree to disagree about some things and support each other when, you know, we come to decisions about how we're going to live together. And, you know, calling out judges, it's a dangerous thing. It's not only just happening to judges, it's happening to state legislators, it's happening to, you know, the executive branch folks too. So,
To be short, I'll be really short.
Well, I actually have a follow-up question to you from your earlier comments relating to what we've just heard, the attack on the justices. Isn't in some way Bondi right in that long-serving judges are all appointees of prior administrations? And, you know, you called out, it was the New York Times, for reporting who appointed those judges who ruled in that way. But doesn't that automatically mean that there's some level of, I hesitate to use the word bias, but interest in the appointment of those judges by the prior president, that they probably had a particular point of view, and doesn't the public have a right to know what that point of view is?
I'll answer that two ways. It's in the appointment of judges, I mean, even to
Come into the mic so they can hear you.
the appointment of judges, including at the state level, is politicized. That you cannot, I mean, I've been through the process, and I was filibustered not because I was a Republican appointee. I was filibustered because, as a senior Democratic senator told me, you're being filibustered because there's a 10th Circuit judge that we do not want to approve the appointment. But it's less obvious that we're targeting that person if we throw 22 other district court judges into the filibuster. And he said, but one thing I'll tell you is that you have the distinction, the historical distinction of being the first group of federal district court justices that have ever been filibustered in the United States. But they did not want this Court of Appeals judge to be approved. So that's the level of sophistication which you never learn about. And we also know that there's a process by which people that get nominated have to go through, and they need an approval, including if there's a blue slip that is not from somebody who's appointed in one state that the opposing party doesn't want to prove, that they don't allow the confirmation hearing to go forward. It's gotten a lot worse than it used to be, but it is that way, and it's on Supreme Court, and we changed the rules for how you can get through Congress and get through the Senate to be approved, depending upon whether or not you want to force somebody onto the court, even though at a later date you might not want somebody to be on because you politically oppose them, that you give up the way in which you can do that within the Senate now.
But you haven't answered my question, which is, doesn't the public deserve to know who appointed which judges who ruled in a particular way?
Only, I would say this, if you went through an opinion and said, here is the opinion, here is what the majority said, and looked at the language of the order to see whether or not there were political motivations behind it, then I would say it's fair to say, and by the way, let's look at who got appointed. The same thing with the dissent. If it looks like it's somebody trying to protect an administration and it doesn't look like the legal argument is sound, then yes. That's not what they did. And I'll give you a personal example. I was assigned the same-sex marriage case in Georgia before Oakville. And the, what did you do in the AG's office at the time? Okay, good. That's all I'm So the AG moved to dismiss it on the grounds that the claims were not factually supported. As we all know, especially if you're a federal judge, it doesn't take a lot of facts to support an allegation to avoid having the complaint dismissed on a motion to dismiss. So the Attorney General's office moved to have it dismissed, and I spent a fair amount and a fairly long opinion explaining why I thought it met the minimum requirements under the federal rules of civil procedure to allow it to go forward. And so I refused to dismiss it. So there were other judges in other states that were also considering the same sort of motions before them. And in the New York Times, there was a list of the judges by name who dismissed and who didn't dismiss. And I was in this minority group with some other democratically appointed judges as refusing to dismiss, making it, and a comment was made in that article to say, well, here's a reasonable Republican appointee that saw that it should not be dismissed. I made a reasonable judgment that the motion before me didn't allow me to dismiss it. Now, there was no analysis of why my motion and my order were different than the motions of the people who did dismiss. But the reporter thought that it was important to show that there are some reasonable Republican appointed judges that will decide these motions correctly. That's the problem.
We are running out of time, and I've got a lot of questions to work through. Let's talk physical security. In all of 2019, 179 track threats by U.S. Marshals against judges, 2021, 224 threats. Last year, 562 track threats against federal judges just through September, the highest on record. Justice Boggs, does that give you pause about being a judge? Is that one of the reasons perhaps you stepped down?
It never gave me pause about being a judge, but it gave me pause about what we could do to fix it. You know, the irony in all of that is that U.S. Marshal Service tracks threats against federal judges. We have no similar system in Georgia to track threats against state judges. We have 1,600 judges in Georgia. Some lawyers, some non-lawyers, some elected, some appointed across 159 counties. And it would not surprise people in this room to know that probate judges that issue weapons carry permits get threats, as do juvenile court judges who take custody away from people, as do superior court judges who handle divorces. And so the problem for me has been that we've never really been thoughtful about thinking forward about the best way to protect our judges in the state of Georgia. So one of the reasons I created the Judicial Security Committee, I'm really proud of the work of Justice LaGrua and that committee in coming up with recommendations largely about protecting judges' personal identifiable information on the internet. I mean, you can go and find people's houses fairly easy on a Google Maps search, but yet we also have no mechanism, protocols, if you will, to gather threat data. So if you ask the Chief Justice at the time, me, how many threats have we had compared to the precipitous, huge increase in threats on federal judges? Over 400% since 2015. What does that number look like in Georgia? And the answer is we have no idea. We have no idea because that probate judge in McIntosh County, who's she reporting it to? Who are they reporting it to? There's no repository. There's no coordinated effort to respond. And there are serious threats against judges across the country. We've seen a Maryland domestic judge killed in his driveway over a domestic case the afternoon he took custody away from an individual. I served on a panel in the U.S. Senate testifying on the passage of the threats against countering threats and attacks on Judges Act with Julie Kacernik, a trial judge in Texas who was shot in the face with a shotgun in her driveway set up by a criminal defendant that she had done nothing more than continue a probation revocation hearing on. And the problem is that it delegitimizes the court system when judges are placed in fear. Arguably, some probably fear to do their jobs.
And what does it do to the rule of law?
Right. It completely eviscerates the rule of law. It threatens the very foundational tenet of the rule of law. And ultimately, we're going to get people that don't want to serve as judges, which will be a horrible effect on the judiciary in our state. So I've been very interested in that issue. I'm familiar with some of the things that are being done. Fortunately, I hope the audience knows that Congress just this year passed the Countering Threats on Judges Act, which oddly for Congress is an act that protects state judges and sets up a repository and a clearinghouse, best practices and so forth. But not surprisingly, I'm proud to say that our Supreme Court, Justice LaGrua and her committee, were well ahead of U.S. Congress in trying to protect our state judges.
Justice Blackwell, let's talk ethics. When the public thinks of lawyers, ethical may not be the very first descriptor that comes to mind, but the fact is, this is the only profession where all the participants in every courtroom, lawyers, judges, sign an oath to the Constitution. How is that enforced? And are there enforcement mechanisms that are failing at the moment?
So, I mean, we certainly have formal enforcement mechanisms, both for judicial ethics, but also for lawyer ethics. For instance, the State Bar of Georgia polices lawyer ethics through disciplinary proceedings. But I think we also have pretty substantial informal enforcement of ethical and professional norms, at least historically, because it's kind of produced by the peer pressure among the bar of lawyers expecting other lawyers to do the right thing and to uphold the finest traditions of the bar.
But does the bar ever take action?
Certainly the bar does take action in some cases. My point is that I think there's kind of a wider enforcement mechanism that's informal. I think we may have lost some of that with modernity and the fact that lawyers no longer practice in the small communities they used to practice in. Lawyers no longer deal routinely day in, day out, at least not all lawyers do, with the same other lawyers. And so I think you lose some of that kind of community peer pressure that enforced a lot of those professional norms in the past. And I think that's something we need to look at how we rebuild that.
Bill Duffey, you were a JAG, you were a U.S. attorney. Judge Martin, you were a U.S. attorney. We're seeing judges rip into the U.S. attorneys now for failing to disclose details, for ignoring court orders. Would that have happened during your time? Could you have gone away with that in your era? Judge Zinnes, for example, in the Abrego Garcia case, complaining her orders have just been simply flouted by the attorneys for the Justice Department. Could you have done anything like that when you were a U.S. attorney?
Well, could I? I could have, but I didn't.
Right. What is driving the change? Is there a change that you're seeing? Judge Martin?
Oh, well, of course, I'm not in court anymore, but, yeah, you know, if there are people standing in the well of the court telling lies to the court, that's a change from what I used to see. I mean, I throughout my 21 years as a judge, I walked into court every day assuming people were going to tell me the truth, whether it was a hard truth or an easy truth. And then I took it from there. But, you know, about the Georgia bar disciplining people that go into court and lie, I think the Georgia bar has taken that on, and I've been proud of them. I've been proud of the Georgia Supreme Court for disciplining lawyers who've been brought up for that. And I mean, that is going on. I mean, it's a long process, and you don't always hear about the result 2 years later or 3 years later. But, you know, I mean, the wheels of justice do grind on, even now.
You four are all retired, and you're able to be on this panel, and You're all being very eloquent on this panel. There's a new ethics advisory for the federal judiciary that makes clear that judges can now speak out against illegitimate forms of criticism and attacks, and further said that the judges may, quote, choose to engage in a wide range of civic engagement activities, including speaking and writing on core judiciary matters such as for the rule of law and judicial independence. Is that a good thing, to allow sitting judges to be able to speak out like that? I will pick on Justice Blackwell because he's looking at me.
So let me say first, I think the code of conduct, certainly the state judicial code of conduct, has always encouraged judges to be active in the community. I mean, state judges have to, they're elected officials, so they have to be out in the community. You don't talk about particular cases, you don't talk about particular issues that are likely to come before your court for decision. But being out there, talking about the rule of law, talking about the judicial system, talking about the legal system, and trying to educate the community on that, I think is a perfectly acceptable role for judges and something judges ought to be doing. That said, I think judges have to be very, very careful in responding to pointed criticisms. It may be warranted to give the judges some leeway to respond to what they perceive as illegitimate criticism, but that always begs the question of who's the decider of what's illegitimate. And I think judges, I haven't seen the new federal ethics rule or advisory opinion, but to the extent it allows that, I would still encourage judges to be very cautious and careful in proceeding down that road, because I think it could be, it may be warranted in the moment, but it could be dangerous long-term to allow judges to get too far out there.
And besides, who wants to hear a bunch of federal judges whining about somebody criticizing them? I mean, you know, I mean, it comes with the territory, right? I mean, we make decisions that people disagree with, and we're not always right, so.
Can I say one thing?
One thing and then we're done. I have a lurking.
There's a February 2026 advisory opinion on this very issue, which is somewhat different than you described it, as far as what the limitations are on judges and what they can say in any public comments that they make.
Okay. Thank you.
Well, that advisory opinion is in your packet. I encourage you to read it. Let's give a warm thanks to all of the Let's get ourselves back on schedule the best that we can. If the panel